Okay, James Cardy.
Good morning.
Morning, James.
How
Nice
are
to
you doing?
see you.
Likewise.
Sorry you couldn't join us today.
My pleasure to be here.
Okay, I did your introduction, so you could proceed with your presentation. Thank you.
Okay. Well, good morning, and thank you for inviting me today to speak to you about estate planning, which is a matter which is vitally important to everyone, young or old. And I understand that this is entitled "Living Your Best Life" for the elders. So I do believe that estate planning is necessary to live your best life because it is an important topic dealing with your responsibilities to your family and to your loved ones, which many times overhangs one's life. And so my approach is really deal with it head on and make sure you've dealt with that and you can go ahead and enjoy your best life. So with that being said, I'd like to try to give you my perspective on estate planning, which I try to approach it from what I perceive as a holistic approach. And so let's start with why, what is estate planning? And then we'll talk about why you need to do it. I'll talk about some various estate planning tools. I can touch on probate and guardianship, but I see that there are very capable and esteemed people on this panel from the surrogate's office, and so I don't, I will defer to them on some of those issues. But just let me know any questions you have. As me as a legal practitioner, I'd be happy to answer them. Anything that I say, I can deal in a hypothetical. I can't give legal advice to the audience, but I would do my very best to give as much information as possible. So we'll touch on some of those basic estate planning tools. And I also want to deal with long-term care planning, because long-term care planning is something that many people overlook, and it can really just blow apart the best laid estate plan. So those are some of the topics today I'd like to try to cover for you quickly. And first is, what is estate planning? It is strategic management of your affairs, both during and after your life. Most people think about it as what happens when I die, but equally important is what happens if there's a disability, if you become sick, because that can have as big an impact on you and your family as a death. And so that's something that has to be dealt with. Estate planning involves family issues and financial issues. And when you bring those two together, that can oftentimes make it very confusing and something that people will just procrastinate and put off and not deal with. I urge you not to do that. If there's one thing that you take away from my remarks today, it is that there is no perfect estate plan, but engaging in the process will be beneficial to you and your family. And so don't let perfection be the enemy of the good here. Get started with some type of planning. That would be my recommendation to you. So why do we need to do estate planning? Well, we need to do estate planning if we're going to be good stewards of both the material blessings that we've been given through our lives, but also the relationship blessings. And I really want to emphasize the relationship blessings, because I do estate planning, but I also do probate litigation. And I've seen many families torn apart, and I've seen the material wealth that people have built over their lifetimes destroyed and wasted in family conflicts. So you have to really not just focus on the material. The material is important, but just as important are those family relationships. And that's why you need to do that estate planning, because it strengthens the family unit. When someone has to engage in estate planning, they have to think about more than just themselves. They have to think about the effect of their illness or their death on others. And when they do that, that helps strengthen that family unit. It also helps to institutionalize economic empowerment at the family unit level. And what I want to give you just a brief example of that. New Jersey has an inheritance tax, which is a tax which is based on who inherits your property from you. And a lot of people aren't aware that by designating someone as a beneficiary of life insurance, they can avoid that inheritance tax with respect to the life insurance proceeds. And so if I give you the example of a family making a simple tax mistake, let's say I have $200,000 that I want to leave to my child and to my nephew, who I've raised as my child. I want to leave them both equally $100,000. If I were to, in my will, leave $100,000 to my nephew, there would be a New Jersey inheritance tax of approximately $15,000. And if I left it to my son, my biological son, there would be zero New Jersey inheritance tax because he's exempt. So just by determining who's the beneficiary of the life insurance, in my example, I could go ahead and make the nephew the beneficiary of my $100,000 life insurance policy, zero inheritance tax. My son gets $100,000 of my other assets via my will, zero New Jersey inheritance tax. And the family as a unit has saved $15,000. Now, and if you think of 1,000 families making that mistake, that's a $15 million mistake for that community. Now, then if you think of that mistake being made over a 10-year period, that's $150 million being extracted from that community via that same mistake from those 1,000 families. Now, my numbers, maybe people may say, hey, they're really big and all that. I'm just trying to illustrate the point that estate planning can have a really significant impact on really maximizing the efficient transfer of wealth from one generation to another. And therefore, making sure that you're informed about what the rules are, tax-wise, legal, otherwise, is very important to making sure that really we don't have that drain, that economic drain on the families and the community. So let me just talk about what is your estate, because this is something that a lot of people get wrong. There is your probate estate and your non-probate estate. And that's something that I think may be well illustrated by an example. If an elder comes in and says, Mr. Lawyer or Miss Lawyer, I want you to draft a simple will for me. I have 3 children. I want them to all be treated equally, okay? So the lawyer just does exactly what the client asks, draws up that will. Those 3 children get 1/3, 1/3. If that client has, let's say, $6,000 in a savings account in their own name, there's no beneficiary designation on that savings account. They have a $60,000 life insurance policy, and one child, the middle child, let's say, is a beneficiary on that life insurance policy. And then the older child of the 3 is joint on the house with right of survivorship, okay? What is going to happen when that will is presented to be probated and everything goes through, let's say it's fine, it's self-proving will and everything works out, those 3 children will not be treated equally, even though the will says, I want my children treated equally. What's going to happen? Well, the $6,000 in the bank account in that elder's name is going to go through the probate process, and that bank account will be distributed out 1/3 to each child, $2,000 apiece. So one child will get that $2,000 under the will. Another child will get $2,000 under the will, but they will also get that house, okay, which is worth $300,000. And then the other child will get the life insurance of $60,000. So there's $62,000 for one child, $302,000 for the other child, and $2,000 for the child that's neither on the life insurance or the house. That's clearly not what the elder intended. But even beyond not doing what the elder intended, what have we done? We have set this family up for a conflict because all 3 children know that the elder said, I want you to be treated equally. I made up a will that did that. But because the attorney didn't pay attention to coordinating the non-probate estate with the probate estate, that didn't happen. And so there are some instances where people will say, look, I got too much money. I'll share with my brothers and sisters. But many times that doesn't occur. And you can see the conflict that can come from that. So that's vitally important in terms of dealing with your estate planning. So I mentioned New Jersey inheritance tax. I just want to briefly talk about other taxes that could affect you in estate planning. The federal estate tax has a very high exemption amount now, and it's like 11.7 million. So it really doesn't affect many people. New Jersey currently doesn't have an estate tax in place. So that's something that people don't currently have to worry about. But if it were to come back, that would be something that you'd want to be aware of and include in your estate planning. So it's really the New Jersey inheritance tax that people have to really think about in terms of a tax impact. So let's talk about some of the basic estate planning tools. A will pass on your property. You'll appoint an executor, someone who will gather up the property, pay the bills, and pay any taxes, file income tax returns, and then distribute out your property in accordance with your will. So the other important thing that two important things that a lot of people don't focus on when they're doing their will is in your will, you can also designate a funeral representative, someone who has the ability to control the disposition of your remains and the funeral itself. And I got to tell you, I have seen horrible conflicts where family members are fighting over the body. And that's something that no one wants. It's definitely not what the elder wanted, and it can really destroy the family relationships. So being able to, as an elder, to speak to the rest of your family and say, look, this is what I want, whether it's cremation or burial, those are important things for you to speak on so that the family knows and can respect, even if they disagree with your wishes. Many times family members will not go into conflict with each other if the elder has spoken in a way that everyone understands is truly what the elder wanted. So that's another way to minimize that type of conflict. And the other thing you can do is if you have any minor children, as I said before, a lot of people focus on estate planning and passing money, and vitally important. If I have minor children, whose household will they reside in? Who will raise them? What type of upbringing will they get? Well, as a parent, I would like to be able to, designate a guardian for my children, for my minor children. You can do that in your will. And of course, the courts are going to look at what's in the best interest of that child. But, many times, if there's not a reason why the person you've designated should not be the guardian, it will carry great weight with the court that the parents have designated someone as the one they thought would be the best place for the best household for their child to be raised. And if a minor child inherits money, it's important to think about possibly using a trust. If you don't have a trust for that minor, well, then their money will be in the capable hands of the surrogate until they get 18. But when they get 18, they will have access to all that money. And there are many young people that at 18, quite frankly, don't have the maturity to manage a large sum of money all at once. And so it's, it can actually hurt some people more than help them. And so it's very important that if you do have a situation like that you think about putting a trust for those minors in your will as well. So I just touched on a will, but a non-legal document that a lot of people don't focus on is a letter of last instructions. And that is a document where you can really lay out a roadmap for family members, saying, this is where you'll find my important papers. These are some old friends of mine that, your adult children may not know you went to school with or whatever back from the day. Give them a call if I get sick or if I pass on. Let them know. It's a place where you can kind of help your family members have that roadmap. It's not a legal document, and we don't put it all in the legal document because there can be legal consequences of putting things in that will if there's ever a contest. but it's a document that's kind of more or less an organizing roadmap for your family members. Let's talk about living will, healthcare, power of attorney, all of those, because that's vital that you have that. This deals with healthcare decisions. You may have heard living will and advance directive. Well, they are exactly the same thing. A living will and advance directive is where you give instructions as to what should or shouldn't be done in the event that you are unable to talk to yourself in terms of, unable to talk for yourself in terms of if you're talking to yourself, that's another issue. But if you're unable to talk for yourself, communicate with the healthcare professionals, that's a situation in which you're able to designate in writing what you want done or not done. Many people will deal with end of life, withdrawal of life support, or DNR issues like that in there. But they are the same thing, living will and advance directive. Healthcare power of attorney is a document in which you appoint someone and empower someone to actually make healthcare decisions for you, once again, if you can't speak for yourself. And we generally suggest doing both. Give some guidelines and appoint and empower someone to be your healthcare representative and really your healthcare advocate. And it's important that you, especially in these days of COVID, that you look back at your documents if you've already done a healthcare power, and you make sure that it has the flexibility in there that gives your appointed representative the legal authority and power to do what is necessary given changing medical conditions. And one example of that is just there are healthcare directives out there and healthcare powers out there where it says under no circumstance do I want experimental treatment. Well, most of the treatments for COVID are experimental. Now, if you get into a situation like some of these states were rationing healthcare, and someone has a document that says, I don't want this, but a family member knows that they would have wanted something, they would have wanted a chance to get that monoclonal antibody treatment or whatever that could actually save their life. In that circumstance, you may face a situation where your family will be at a legal disadvantage. The hospital or facility may hold up the document and say, we're going to follow the document. This is your family's wish. This is your loved one's wishes. And we are not going to really listen to what you have to say at that point. I have seen situations where that has occurred, even outside of the COVID situations, where when withdrawal of life support situations, hospital has said to one family, look, we are going to withdraw life support at 12 o'clock noon tomorrow, regardless of what you family members think. We have a document here that says we can do it. And we're going to go forward with that. So whoever relative needs to get here, they need to get on a plane and get there right away. And I'm not saying that's going to happen, but if something like that were to happen, if you're going to protect your family and protect yourself, you want to empower someone in your family that you've chosen to be able to push back and say, no, actually, I have the ability to override those wishes. And that's not what they meant. That's not what their lawyer meant, because even the best lawyer in the world can't get everything right when circumstances change. It's impossible. So that type of flexibility, I am urging many of my clients to put into their healthcare powers. And especially when we talk about structural racism, okay, which is in the healthcare delivery, it's something that is in society. And if you just look at the horrible statistics with Black women and maternal health, and all of those statistics there's ample data that says that there is a problem. And the legal community, I believe, has a duty to help clients address that problem, protect themselves from it. And one of the best ways you can do that is by empowering your family members. And if they need to, they have the legal authority to go to a court to move someone to a different healthcare facility and get the treatment that they need or that they think is appropriate. And that's not to say that you want someone to override your final wishes. What I'm saying is what you want to do is have that family discussion, pick people whose judgment you trust, and then legally empower them that, God forbid, they ever find themselves in a situation where they're being treated with disrespect and they're not able to advocate for you in the way that you would want them to. They have the legal authority to push back. And so those are just a few things on healthcare powers and advanced directives. With respect to general durable powers of attorney, that is a document that is vital that you have. It's a very simple document, but it can save you from going through a guardianship proceeding many times. And I think the surrogate people may be able to tell you about guardianship. And if it's a guardianship that's uncontested, it takes a little bit of time. It costs more than the power of attorney, but it may not be the end of the world. But a contested guardianship, I got to tell you, I've been there. I've represented a sister against her brother fighting over who's going to care for their father. It tore the family apart. I was in court and family members are lining up on each side saying horrible things about each other, trying to show that this person isn't fit to be the guardian. At one point, a lady picked up her child and ran out of the courtroom with her child, so he would not have to hear the things that relatives were saying. So if it's possible to avoid a contested guardianship, you definitely want to do that. And the first step towards doing that is getting that general durable power of attorney in place, where you appoint someone who can manage your financial affairs in case you become disabled or you lose capacity. And there are a lot of general durable powers of attorney that are out there that are what we call springing, which means that they don't come into effect until 2 doctors have certified that the elder who gave the power of attorney is actually incapacitated. And I am advising my clients that they should seriously consider of changing, if they have a springing power, of changing that springing power and making it immediately effective. The reason being is during the pandemic, sometimes doctors don't like to do paperwork because they're focused on healing people. Okay, so during the pandemic, trying to get 2 doctors to focus on that has caused delays. And one of the advantages of the general durable power is if it's in place, you can immediately have someone who can actually start making financial decisions, as opposed to waiting to get court authority to do that. And you can lose that advantage if it is springing and you can't get the doctors to really respond to you quickly enough. So that is something else to think about. With respect to trust, I want to just briefly touch on, you probably heard of living trust, revocable trust, living trust, avoid probate, da, 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 da. I mean, those are some of the commercials that you may have seen out there. And here's my view of it. A living trust, a revocable trust, it is a tool, okay? It just like a hammer or a screwdriver, it's a tool. The real question is not whether you do a will or revocable trust. The real question is, what's the problem you're trying to solve? And what's the appropriate tool to use to solve that problem? So if I have a situation where I have a small business, okay, and I own, let's say, and if the small business were to go through the probate process, which takes time and there may be disputes, that small business most likely will not survive the probate process. I've seen it many times, especially as service-based business. It can be destroyed going through the probate process. That may make sense for me to have that business in a revocable trust, which would avoid that business going through the probate process. So there's someone, a trustee that I appoint, who could then go ahead and manage that business through the probate manage that business after my death immediately. They could pay employees, pay the rent, make sure that customers pay, all of that. So that's something that's important from passing on wealth from one generation to another. Small businesses, a lot of them don't survive that transition. A revocable trust could be a good tool to help with some other business succession planning. Also, if you have real estate out of state, So if you own property, let's say in Georgia, or you own property in California or Florida or some other state, you don't want your family to have to first probate your will in New Jersey, then take certificates from the surrogate in New Jersey to that other state and go through the probate process with that property. That can be expensive and time consuming to do, where if you had a living trust, revocable trust, it's the same thing. You could actually have that property inside of the trust. So the owner of the property never died, okay, because the trust owns the property. Therefore, that property isn't going to go through probate in that other state. And probate in New Jersey is not, at least my experience, is not very difficult or complicated compared to a lot of other states. But some states, it could really cost you quite a bit of time and money to have to go through the probate process on family property you may own down south or somewhere else. So those are very good reasons for having a revocable trust. And a revocable trust is a trust you set up while you're alive. You're able to manage your assets in that trust the same way as you're managing them now. And you can revoke that trust, just like the name says. So you really maintain control over those assets. But the advantage, as I said, is that you've appointed a trustee that if you pass on, will immediately have authority to manage those trust assets. And if you become disabled, it's actually a superior tool than a general durable power of attorney. Because with a general durable power of attorney, when your loved one goes to that bank or financial institution, they're going to be looking to see whether or not that power of attorney is still in force. Was it revoked? How old is it? Lots of times, if it's over 5 years old, a lot of financial institutions give people a hard time because they don't know whether that's still in force. So that's the difference with a revocable trust. The owner of that bank account, the owner of that brokerage account is the trustee of the trust. That bank, that financial institution will have a much harder time pushing back on your loved one when they come in saying, I'm the owner of this account and I want to engage in this transaction. And so it can be a superior tool for managing assets during a disability as well. The disadvantages of that tool is that you have to set it up while you're alive, and it is more expensive than just doing a will. And it may not be appropriate for your situation to incur that expense and incur the trouble of setting that up. And in that case, you wouldn't do one. But that's something that you really have to look at what's really the right, tool to use in your situation. So I just briefly talked on trust. I want to also, if I could, I think I don't want to touch too on guardianship. I really don't know where my lane is here because I'm looking at these people who I know tons about the process because they kind of run the process in Essex County. so I'm going to defer to them on maybe guardianship and some of the probate things I would have said, and just maybe talk briefly on long-term care planning because and Medicaid planning, things of that nature. It's something that a lot of people don't take into account. As I said, it can really destroy the best laid estate plan. I've seen so many situations where people come to me and they've worked hard their whole life. They've saved something, they've built a little something, and then there's a sickness, there's an illness, a disability. And now the elder is forced with, how do I pay for care? Okay, that is something that most of us, well, I would say all of us in this room really need to think about. The statistics say that, people over 65, more than half of the people over 65 are going to need some type of long-term care at some point in their life. The average stay is somewhere around 4 years if it's in a facility. The cost in a facility could run $10,000 to $20,000 a month in New Jersey, depending on the facility. And if you think of that, think about, let's just say $20,000 a month. Do that for a year, we're talking about $250,000. Do that for 4 years, we're talking about $1 million. That can wipe out a lot of estates, a lot of generational wealth that people thought they were going to pass on can disappear with a long-term disability. And so that is a risk that must be part of your plan. If it's not, you will be surprised. And the magnitude of that risk is so large, as I just stated. The cost is so high, and the likelihood of it occurring is so great that it's one that has to be included in the plan. You know, so how can you deal with that risk? One, if you have long-term care insurance, that's one way to deal with that risk. A lot of people don't have that, but if you do, if you're fortunate enough to have that, or you're young enough to be able to get that at an affordable price, then that's something to seriously consider. If you're a veteran, there may be some veterans benefits that can help you with those costs as well. But putting aside long-term care insurance and veterans benefits, really for paying for long-term care, it's either using your assets and your income, private paying, or Medicaid. And the way it's set up is without any planning, most people will use up their assets and then be converted over to Medicaid. And so Medicaid planning for long-term care has two objectives. The first objective is to accelerate the eligibility of the elder for Medicaid. So we can get public dollars flowing in sooner, before assets are depleted. And then second, making sure that when the elder passes on, there are no assets in their estate for the Medicaid lien to attach to. So let me explain what I mean by that. Medicaid is a means-tested program. You can only have so many assets and so much income for Medicaid to pay for your long-term care. And so to be eligible for an individual, you can't have more than about $2,000 of countable assets. And your income can't be more than about $2,300 a month. You know, the income's not usually the big problem, because you can use something called a qualified income trust, and you can get assigned that excess income to that trust and have that pay for medical bills and get under that income cap, okay? Assets is where most people face the big issue, okay? So getting under $2,000 of countable assets is something that a lot of people think of, well, why don't I just give to the people who I want to inherit from me? When I get sick, I'll just give my house to my kids. I will give the bank account to my kids now. Well, there are reasons why you may not want to do that, because your kids may have creditors that could get to that property. But even putting that aside, Medicaid has a 5-year look back. If you give gifts within 5 years of applying, of actually putting in a Medicaid application and being medically qualified, where you need the assistance for that type of care, if you do it within 5 years of that, they will look at whatever gift you've given and assign an eligibility penalty to you. And the way that works, just very briefly, is let's say I give my kids $100,000, and 4 years and 11 months ago, I gave my kids $100,000. Okay, I now on the 4 years, 11 months, I apply for Medicaid. And let's say I have no more than $2,000 left. Okay, so I think I'm good. Medicaid asks, well, what types of transfers have you made within the last 5 years? And lo and behold, they see $100,000 went to the kids. What happens? Well, they apply a penalty. And these aren't real numbers. This is just to make the math easy for me, is let's say that penalty is $10,000, you know, the hypothetical monthly cost of a stay in a nursing home in New Jersey. I know it's way lower than that, but let's just use that. 10,000 goes into 100,000 10 times. The penalty that's going to be applied to me is a 10-month penalty that I am ineligible. The elder is ineligible to get Medicaid to pay for their long-term care. Well, when does that penalty start to run? It doesn't start to run 4 years and 11 months ago when I made the gift to my children. It starts to run when I have put in my Medicaid application. I have no more than 2,000 assets that are countable in my name, and I medically need Medicaid to pay for my care. Obviously, that's not the situation you want to be in. You want to, trying to go back and get the money from your kids, or having an attorney trying to make an appeal to an administrative law judge to try to get an exception for a hardship. You don't want to plan for that. It'd be better for you to instead do some planning ahead of time to avoid that type of penalty if possible. And if you can't avoid that penalty, to use some of the Medicaid planning techniques that would allow you to maybe preserve some of those assets. Okay, so I just illustrated a little bit about the 5-year look back and the penalty and getting eligible. And I said that you also want to make sure that there aren't any assets left in this elder's estate, because Medicaid has the right to get paid back from your estate for all the care they give over your lifetime. I think after age 55, they have the right to get paid back for that money from your estate. So if there's anyone in your family that's leaving property to an elder, you don't want to leave it outright to an elder, because all you're going to do is make them ineligible for Medicaid themselves, and it's gonna cause a problem. You don't want anyone leaving property to you, and you want to get out of your estate any property you have, so that other than the property that you want there to expose to the cost of long-term care. And so one of the issues that I find with a lot of my clients, the lawyers are great and we can come up with great strategies on how do we protect assets and all that. But the real life issue that a lot of elders have to deal with is, to effectively protect my assets from the cost of long-term care using Medicaid planning, I'm going to have to give up control over some of these assets. And that is a very difficult issue. And it's one that elders have to really think about, because remember, when you're doing your planning, your estate planning, which includes Medicaid planning, okay, you're planning for the management of your affairs during your life. You've got to take care of yourself. And so many elders I suggest to them, the old saying of, God bless the child that has their own. You want to keep a little bit of money for yourself to, if you have it, and to expose that to the cost of long-term care. So no matter what happens, you don't have to ask your children or whoever you've put over that money in a trust, a Medicaid, irrevocable trust, to get access to those funds. So you want to kind of hedge your bets. Some money I'll expose to the cost of long-term care. Some money I'll put in a lockbox, and I'll try to save to be able to pass on wealth to the next generation. And that's kind of one way of looking at, using Medicaid planning as part of your estate planning and I'm probably going way too long. So let me know, moderator, on the Zoom. I can't tell if I'm going too long. Just let me know.
Okay.
I want to share what I could, and so I hope that's helpful.
James, you did an excellent presentation, and you certainly kicked off this event with the information that is so necessary to our community. We had discussed this at our last event about legacy and leaving legacies in our community. And I certainly appreciate all that you said and provided to our audience. Again, if anyone has any questions, they could put it in the chat or in the Q&A on the Zoom link. Currently, there is none, so it sounds like you did an excellent presentation. I did put in the chat James Carty's contact information should you require an attorney's assistance, his address and phone number. Thank you, James. I'm hoping you're able to stay on in case someone else has any questions.
Sure.
Our next presenter is Gina McKinney. Ms. McKinney is a final expense and Medicare specialist with 7 years of experience in the insurance industry, as well as over 20 years of experience as a public urban educator and administrator. As a former educator, transitioning into insurance was seamless. Building relationships is the most important aspect of working with her clients. Her goal is to deliver peace of mind for her clients and their loved ones. Ms. McKinney is an independent final expense specialist with Lincoln Heritage Funeral Advantage and works with several Medicare supplemental insurance companies. Ms. Kinney will be providing a presentation on Medicare eligibility and trying to navigate that. As many of you know, we're in the open enrollment period at this time. So I think this is a timely conversation. So Ms. Kinney?
Good, is it afternoon? Almost. Good morning, and Mr. Cardy, is that the last name? Thank you so much. That was a very informative because a lot of what you spoke about does concern final expense, which my partner will speak on, but also Medicare. And this is also something that needs to be a part of family planning because Medicare is something that the family needs to be knowledgeable of. My parents are like my children now. And so they do not make a move unless I am at the table, unless I am knowledgeable, because when it comes to Medicare, you all have raised us, you all have worked, you all have done everything that life has expected, but then you have to go back to school and figure out this Medicare game. And so as Ms. Richardson did state yesterday, October 15th, did start the annual enrollment period. That is a period where the government allows those who are already enrolled into Medicare to shop around. Why? Because every year the government allows the insurance provider to make changes to every single Medicare plan. But unfortunately, our seasoned saints, that's how I qualify our 65 and older community, they do not do the necessary research to find out what changes are forthcoming. And the biggest challenge to our community are the prescription drugs. So as a child, what I'm doing is I'm watching my parents and I'm trying my best to avoid what they did to get on these prescription drugs, because that is what our seasoned saints cannot afford. It's not the hospital, it's not the doctor, it's the prescription drugs. So every year, if we are not checking the prescription medication for our loved ones, we are doing them a disservice as children, as grandchildren, as friends, and as family, because that is what changes every single year. So I'm just gonna speak briefly on what Medicare is, and to keep myself guided, I do have my little cheat sheet because I am a preacher as well. So I can keep talking and talking and talking, and we don't want to do that. And so again, Medicare is federally funded by the government to those who are 65 and older, or those who have been disabled for 24 months, or those who suffer from end-stage renal disease. And how do you qualify for Medicare? By working in this country, being an American citizen and a legal resident. And so when it comes to Medicare, it's Medicare Part A and Medicare Part B. Medicare Part A is free. You receive that because you have worked in this country for at least 40 quarters, or what amounts to 10 years. Most times you will be automatically enrolled into Part A. There's nothing that you need to do. Part B and Part A again covers your hospitalization. That is what Part A covers. Part B is what you have to pay for. Part B is what comes out of your monthly Social Security distribution, depending upon your income. Now, for those seniors, as Mr. Cardy has spoken, those who do fall under Medicaid or fall under the poverty level, they may not have to pay their Part B. And they also may be eligible for plans that give them a Part B kickback. So your Part B eligibility and income is based on your income level. And so right now, I believe going into 2022, if I'm not mistaken, the Part B premium is $148.50, and it goes up every single year. But again, that is basic. But for our wealthier citizens, that increases. And so even your Part B income is based off of what you make. So I'm in Essex County. I have some expensive Essex County clients in Essex Fells, North Caldwell. They are paying upwards of $500 to $600 a month for their Part B premium. So if you do make above a certain income, the federal government will come for that income. So that Part B premium is not just stagnant, it really is contingent upon what you bring in terms of income. You can choose private plans to get your Medicare coverage. So back in the day, Medicare was only offered one way. The red, white, and blue card was your Social Security. And Medicaid was your Medicare coverage, but Medicare only covers 80%. Please make note of that. Medicare is only covering 80% of your healthcare costs. You are on the hook for the other 20%. So back in the day, what was available for you to take care of that 20% responsibility was something called Medigap or supplemental insurance. That is when you pay a monthly premium to a private healthcare company, and you've heard of those letter plans, Plan A, Plan B, Plan C, Plan G, high F, low F, MN, all of that good stuff. Well, those are plans that are designated to cover your 20% responsibility. Here's the issue. Those premiums go up every single year, and they get to the point where they're not affordable. And so what the government came up with was a secondary option called Medicare Advantage prescription drug plans, otherwise known as Medicare Part C. So this can all be confusing. So I've already said Medicare Part A covers hospital. Medicare Part B covers your doctors and your specialists. Medicare Part C combines all of those on one card. So when you have Medicare Part C, which is known as a Medicare Advantage prescription drug plan, that one card covers Part A, you take it to the hospital. That same card covers Part B, you take it to your doctor, you take it to your specialist. That same card also will cover, here's another alphabet letter, Part D. That's for your prescription drug coverage. So Medicare Part C covers A, B, and D all on one card. These Medicare Advantage plans, most of them don't have a monthly premium. That's why many people choose them. They're affordable. They also come with a lot of free advantages. So I'm sure you've heard of Silver Sneakers. That's a free fitness program that comes with your Medicare Advantage prescription drug plans. They also have benefits known as over-the-counter benefits. That is where some plans will give you money every quarter to use to pay for certain over-the-counter items. Because again, the purpose of Medicare and my job is to make sure we keep as many dollars in the pockets of our seniors as possible. Because by the time they hit Medicare, they're not working like that. So there's not an expectation of a lot of income coming in. So that is why we have to be very careful to shop every year to make sure that you are in a plan which reaps the most benefits for you. And so again, when you look at your Medicare, 65 is when you begin your Medicare. Now, when you're going into your 65th birth year, that's called your initial coverage enrollment period. So 3 months before your 65th birthday, the month of your 65th birthday, and 3 months following your 65th birthday is the amount of time that you have to enroll in your Medicare coverage. Again, if you choose to work, that's not an automatic. There are certain things that you need to do. And so what you need to do is you need to talk to your human resources at your job to make sure that they will continue to offer you credible coverage. Because some employers, depending upon how many employees they have, may make you go ahead and enroll in your full Medicare Part A, Medicare Part B. And so these are conversations that you as the consumer have to have with your human resources representative to see how they carry their employees who choose to still work beyond year 65. There are some of you who are a part of your spouse's healthcare plan. It's not a guarantee that your spouse's employer is going to cover you in retirement. So again, these are important conversations that you have to have with the human resources representative who gives the healthcare coverage through your job. Because if you do continue to work, and your employer allows you to remain on the healthcare, what it means is they will be the ones to pay out first. Medicare would then be secondary, but you may not have to opt into the Part B. You can hold on to that $148.50 for a little while. And as long as what you have is considered credible coverage, you will not be in penalty. But if you don't have credible coverage and you choose not to enroll, you will pay a penalty when it is time for you to enroll in Part B premium. Again, if you have credible coverage, Once you lose that credible coverage, you have 63 days to enroll in your Part B premium before you receive that 1% penalty. And that 1% penalty will increase annually until you enroll in that Part B premium. Are there any questions from my ladies in the audience or anybody on Zoom right now about anything that I've shared about Part A, Part B, Part C, or Part D? Yes, so the question, yes, that is a month, but again, that comes out of your monthly Social Security distribution. So you are not cutting a check, you are not making a payment. Whatever is designated for you to receive each month, it will be minus your Part B premium. And again, those premiums go up every single year. You got it?
For Part B premiums, and if you cannot, if you pay more than that, then they will reimburse you.
Well, again,
I'm sorry.
it sounds like what you're speaking of, if you do the 148.50 times 12,
adds up
that's
to
the
that.
annual.
Okay.
But that goes up every single year.
Okay.
Like I want to say the year before, it might have been 144.50. So it's not a major jump. But again, any incremental jump when your income is not increasing is something we need to be mindful of. But again, that comes out of your monthly distribution. It's nothing that you have to personally come out of. Whatever's deposited into your account is just going to be minus that. And again, depending upon how your taxes are done, if your income changes, they will make the adjustments to what that Part B, that's through Social Security, and I don't work for Social Security.
Okay.
So yeah, when it comes to SSA, again, when you are approaching the 65th year, as I tell my clients, it is very important that you make an appointment with your local Social Security office. Sit with them, get educated, because Social Security is who you need to go to understand the Part B. When you come to me, I can't help you unless you have Medicare Part A and Part B. That's the thing. You can't enroll into any Medicare plan if you do not have your Part A and Part B premiums together. So when it comes to those Social Security questions, I stay in my lane, because when you don't, you cause accidents, and we don't want that to happen. So I encourage you to call your local Social Security office, make an appointment. And from my clients, that has been one of the best experiences that they have had in Essex County, Passaic County, and Bergen County when they have reached out to those offices.
So we shall be getting a 5.9 increase. That might necessarily make our contribution of the 148 go up, or is there a threshold? Does it have to?
Well, you must be talking about, what is that in the news, that 5.9? And because I mean, in the news, I heard something about a 5.9 increase.
Yeah.
So that's what you're talking about.
Yeah.
No, I don't believe that that will be an impact. Again, that's not my area of expertise, but you do make a point. So that's a question for Social Security to see if that increase is going to affect you, but I don't think it would affect you,
Well,
the threshold like that.
yeah, they send out the form every year to let you know. So I've kind of figured it out if I do
Okay.
get that 5.9, you know,
Okay.
how much more I'll get monthly,
Okay.
and how much more I'll get for the year, but on the same amount that they're taking out. from me.
Okay.
And my other question is, would, I work for the state, so out of my pension, there's a certain amount that comes out for my medical. So would that be in the same line as Medigap?
Well, that sounds like you might be paying into an HSA. If they're taking money out of your pension, that sounds like you might be putting into a health savings account. I'm not too sure. And if you're continuing to work past 65, okay, but just if there are those who are listening and they are paying into an HSA, that has to stop. Once you turn 65, you can no longer pay into a health savings account. And that is information that should be shared. That information, let me read it to you verbatim, so I can make sure. Yes. So what if I work past 65? Pay attention to details. You must stop contributing to a health savings account once you enroll in Part A or Part B. So you have to check with your employer plan benefits administrator. Again, it's very tricky. If you continue to work beyond 65, that's when you have to have a conversation with your employer to make sure that you are following the proper Medicare guidelines based upon the kind of employer they are. And that's really based on the number of employees. That's how the conversation changes.
Well, prior to my retiring 11 years ago, the state said if you worked 25 years, you would automatically still be like covered by them, but they still take out so that covers the other 20%. So
So
that's why I was just wondering if that was considered Medigap too.
no, that's not Medigap, but you are unique because you represent somebody I couldn't help. See, it sounds like you get your Medicare coverage as a retiree from the state. I can't touch you.
Okay.
I touch and I help people who are independent on their own. Because if you allow me to help you, you can't go back to what the state offers. So yeah, that's something totally different what you're talking to, but what you're referencing is not Medigap. She receives her Medicare benefits as a state. So teachers, different people like that, if you work the 25 years, your Medicare is covered through the state. So any changes, any questions would all have to be directed to the state of New Jersey. So when it comes to that 5.9, that has to go to the state. That's who you speak to, just to make sure.
Also asked in reference to my ex-husband, so I could give him.
Okay, no, and if he's not covered by the state, he's independent, so I can help him. But to her point with Medigap, Medigap is supplemental private insurance. And so again, that's the the plan A, plan B, plan C. So that is when you pay a monthly premium to Aetna, Humana, WellCare. And so that private insurance, that Medigap, that supplement, that covers the 20%. Most people who have those letter plans, they don't pay anything for medically covered services. But again, we have to be careful because those premiums go up monthly. And I met an ophthalmologist the other day, his mother's 93. Her premium's almost $500 a month. But think about when she was 65, did she think she was going to have it for 28 years? So these are things to think about because those plans can get pricey, but it's really all based on your health condition. And we can talk about that momentarily. Yes, ma'am.
Hi, I have a 93-year-old aunt that I take care of, her paperwork, read all of her mail because she doesn't want to and she's afraid of it. So, and she's also a retiree of Merck or Schering-Plough as it was.
Okay.
So basically, she's not really sick. The only medication she's on is for hypertension and Coumadin and Lubigan, which are eye drops. That's it. She's not sick. She has a spending account through Merck. And then she also has Medicare, obviously. And then she also has Aetna. So is she covered? From what I'm understanding, all bases are pretty much covered. She never really depletes her spending account. She probably uses about $2,500 because of the out-of-pocket expense for the Coumadin and Lubigan. And she just has like a carryover every year. So there's almost like $10,000 in there now. So my question to you is, what happens with that spending account? Let's say, should she pass away? Is that money just there and it just goes back to Merck, or is that part of her estate?
Well, let me ask, but it sounds like she gets her coverage through her employer. She's not independent. It sounds like she's getting her Medicare benefits from her retiree, from her employer. If this is still connected to Merck, that's what it sounds like. How many years did she work? It doesn't sound like she's independent. It sounds like she's like this young lady right here. All of her Medicare is tied to Merck. She's not independent.
But her Social Security is attached every month for payments for Medicare.
Yeah, I'll have to talk to you off
Okay.
script just to get a clear understanding, because again, I
Okay.
don't want to
I probably
misadvise
need-
somebody who is tied to employer. Again,
Okay.
I work independent, people are on their own, so we can have a private conversation upon this because I don't want to misadvise. I just want clearer understanding before I answer your question.
Okay, one
Mhm.
other question. My mother, I take care of her business too. She's 85.
Okay.
That's her sister of the 93-year-old. Now, she has Medicare, but she also has a secondary in Cigna based on my father's job, who passed away about 6 or 7 years ago.
Okay.
So she has Cigna as a secondary, so she's fine. I don't have to worry about what's coming in for her as it relates to Medicare.
Well, again, it sounds like she's covered through your father's employer.
Yes,
So those questions have to go to them. If I guided you, it would be off market. And
yes.
if I helped you, it would take her from whatever she's had all of these years. So again, if she's covered under your father's plan, the question you want to ask, you just want to call them to make sure. But most people who have employer coverage, you're good to go. It's the independent people that need my assistance. But when you are covered by your employer, they do all of the negotiating for the plans that they have for their respected
I see.
employees. So if you have a question just for your peace of mind,
Mhm.
just reach out to their HR department just to answer those questions, because she's still being covered by your father's employer. So that's who you need to go to, just so you can have that peace of mind. But most times they're not impacted because they've negotiated
Yes.
and they've taken care of their plans. And there are very few changes
Yes.
here and there. So it sounds like both of them are in good hands because they're in employer
Right.
covered
Right.
packages. They're not on the independent market fending for themselves.
Okay, now my brother, who I also take care of,
You just,
He has-
who taking care of you? We here. We are
don't
here.
get me to crying.
We are here.
But he has a disability, so I take care of his paperwork too. And being that he just turned 65 in August, I got him a secondary with Aetna because he didn't have, I guess it's the Part B.
How long had he been disabled though?
He's been disabled. He's 65 since he was like maybe 25.
So you're,
So he's schizophrenic. So,
But
and he
he-
doesn't work.
so he's had Medicare, because when that's one of the
Yes, he's
stipulations.
had
He's
Medicare.
had Medicare because 24 months, that's
Right.
automatic. Mhm.
Right, but because of that, and because he turned 65, we had to get additional coverage for him just in case.
Okay.
So, and he's paying like I'm paying $110 a month for that supplemental.
And it
insurance.
sounds like you have the private, you're paying for a letter
Yes.
plan.
Yes.
We can have a conversation, because again, when it comes to people deciding whether they want to pay for the private to cover their 20%
Mhm.
or go for the a la carte option, like my mother, she's like, I'm not paying anything. I'm not like your father. I'm paying my copays as I go.
Right.
You have to really think about the medical and the healthcare needs. And so if you look back at your family history, if there weren't a lot of hospitalizations, you just really go, your brother goes to the doctor just for the basics, that really could be a Medicare Advantage plan where they don't have monthly premiums. The monthly private is people who have a lot of operations. They have multiple specialists. They're always in the hospital. They have a very heavy history of medical. They're the ones who really benefit from that private Medigap insurance because they're constantly in and out of the hospital.
And he's not really, other than, every now and again with the psychiatric episodes, he's fine. He's physically, he's
so-
fine.
We can have a conversation, because it seems like with your brother, we shop every year and we really shop based off of the drugs. But this would be a private conversation
Okay.
where we would have, because I don't remove people from those private plans unless they can't pay their bills. Like
Yes.
if I have a seasoned saint who says I can no longer eat or do something like that, then I have to switch them. And it really hurts me to do that, because then they're going to start paying for services they never paid for before.
Right.
And the only reason they were in this plan is because that was all that the government opted for them. Medicare Advantage plans were not always around.
Right.
And so again, we can speak privately
Okay.
about your brother so we can kind of look at what the best options might be for him.
Okay.
Okay.
Thank you.
But thank you so much.
Gina, thank you so much. Again, a wealth of information. I've known Gina all her life. So it's just a blessing to see you present today. Our next presenter is our Essex County surrogate, Altariq Kenny. He was sworn in on January 2nd, 2019. It's his first term as the surrogate of the county of Essex County. In his elected role, he is the constitutional officer and the administrative judge of the county surrogate court. The surrogate's court responsibilities include validating wills, appointing administrators for those who died without a will, and reviewing and assisting with documents surrounding adoption and adult guardianship. The court also schedules adoption hearings as well as Superior Court probate part case hearings. Surrogate Kenny, welcome and thank you again for joining us today.
Good afternoon, and thank you for hosting this program. I do appreciate the opportunity to talk to you about why this process is important. It's interesting that we're having this conversation in what is titled the James Brown, African American Resource Center or Resource Room. And to know James Brown is to know that what estate planning or the context of estate planning is as it relates to this conversation. James Brown died on Christmas Day in 2006. 15 years later, this year, James Brown estate was finally settled. And so, it just gives us sort of context as to, why estate planning is critically important, regardless of what your financial level is. You could be James Brown, who actually had an estate, whether it was a trust or a will, or you could be somebody like, Aretha Franklin, who unfortunately passed without a will. And so that kind of describes 70% of African Americans in this country who unfortunately passed without a will. And as James stated earlier, we're talking about actual wealth that can impact generations. And so there was one report that stated that $1 trillion of assets in the African American community will be determined, in the next 20 years based on how well you financially plan. And there was another report that stated that $2 billion annually is spent in probate and 1.5 is spent on attorney fees. And so, it's a real, issue in our community. And in the last year, we've noticed, that there's been an upchink in deaths that happened as it relates to COVID. And so nationwide, 725,000 people died. In Essex County, 3,100. Even though we are the second, most populous county in the state, we have the highest number of COVID-related deaths in this area. In the state. And so it kind of sort of gives us, the reason why we decided to not only evolve out of what we do regarding our court, and thank you for reading our background, our bio. We also decided, to make sure that we have these sort of intimate conversations with communities, specifically communities of color. And we were able to bring on Nikki Hamilton Moore, who was able to help us have these sort of conversations where we're able to answer questions in real time. And so I'm not going to take up a lot of time. I want, our deputy, who's well versed in this subject matter, to not only give a background, but really open the conversation up so we can answer questions, to ensure that we're able to address the specific issues that relates to probate court. James did an awesome job, laying out the background, the history, the facts, and hopefully we can mirror his energy and enthusiasm to ensure that we're able to answer questions in real time. And DeVero does an excellent job. We typically have these sort of presentations with attorneys like James, where we're able to go back and forth with individuals to answer questions, as it relates to probate. Sometimes we have conversations regarding guardianship. We also have conversations regarding a number of state-related matters, but specifically to this conversation, we wanted to make sure that we tailor this conversation to address the needs, with people who are, in this particular room. And I'll just give you just one fact before I turn the conversation over to DeVero. In our community, we see one of the biggest reasons why people don't create plans, estate plans like a will or a trust or whatever, is because one of the most prominent reasons is procrastination. A number of people who stated, well, I'm going to do my plan today. They don't use today to take advantage of it, and tomorrow's not promised. And so one of the biggest reasons we noticed was, procrastination. The second reason we also noticed why people don't create plans is because they feel, well, I don't have anything to transfer. My estate is not as large as James Brown. My estate is not as large as Aretha Franklin. My estate is not as large as Prince and Nirvana, all these people who had a will and didn't have a will, or Bob Marley. And you have something, and as James stated earlier, is that it's our ability to talk from the grave, to protect our families, to keep our families together. And so to echo James' point, this is our opportunity to ensure that we're able to transfer our assets without minimizing the amount of arguments that can occur amongst family members as you speak from the grave. The third thing that we also notice is that we think that the older we are, then having a will is more critically important. We don't know when death occurs, right? We don't know when we're going to transition. And so I always, there was this story about a gentleman out of California. Some of the people in this audience know Nipsey Hussle. He was a famous rapper, and he died, I think he died in his late 20s or early 30s, whatever his age was. He's much younger than me, but he died early, and he had all his assets. And the assumption was he had a will, he had an estate plan, he had a trust set up, and that wasn't the case. And to echo James' point, he also had 2 children. And the question was, what happens to his children after his death? And so those are the sort of real life issues that occur. You never know when you're going to transition. You're called home when when the Creator calls you home, if you have that sort of belief system. And so we want to make sure that today, when you leave this conversation, one, you have life insurance, as the previous presenter said, why is it critically important? What it means, in terms of having assets, not leaving your family with debt, but leaving them with something, beyond what most families leave if you live in the African-American community. The second part of the reason why we think this is critically important is because we have to plan. And planning is so critically important, to protecting what we've created over the course of our lives. So, for example, in an African-American community, 52% of what we own is our house. And so I'm not sure about you, but I'm getting phone calls daily, asking me to sell my home. People are texting me. I don't know how to get my information, but they're asking me, can I buy your home pennies on a dollar? And so they don't know what my situation is. And so, I'm fortunate enough to be an informed, consumer and informed homeowner. But there are people who are actually selling their homes because, they have to pay down debt that was inherited from previous family members, or they may sell their home because they weren't able to have some unresolved issues amongst family members about what to do with mom's house or dad's house. And so those are sort of things that we want you to at least walk away with. And so I'm going to turn the conversation to DeVera McDougal. He's a very informed, deputy's one of the smartest throughout the state. I have to brag that Essex County has one of the smartest, most capable people in this space throughout the state, who's also a CPA as well as an attorney, and who does a great job to ensure that we are able to do our job at Essex County Surrogate Court. And thank you. And I have to go. I have a hard stop. I had a funeral this morning. I have a family outing right now, and I appreciate the invitation as well. Thank you.
Thank you very much, and for all your service to our community.
Thank you.
Mr. DeVara McDougal.
Yes, it's pronounced DeVero. So first, let me thank the surrogate for the introduction. Let me thank the Newark Library for having Essex County Surrogates Court. One of the things I want to add that the surrogate, didn't mention, because he tries to be modest. So yes, this is his first term, but what he did when he came in is to make sure that we did community outreach, that people understood the importance of estate planning. Because when people come to the Essex County Surrogate Court, any surrogate court throughout the state of New Jersey, it's one of the toughest time in their lives. And what we get to see is many times those family members come in having to do what we call administration. And that's administration happens when somebody doesn't have a will, it's intestate. And it makes life harder for them as opposed to if there was a plan in place. I heard the term estate planning, family planning, and as far as I'm concerned, it's all the same thing. And so I'm going to do something a little differently, since Mr. Cardi and I believe it was Ms. McKinney started and got a lot of substance. So I'm going to eliminate the PowerPoint. And actually, you actually talked about what the surrogate court is. So just let me kind of go through that real quickly so people can understand, because the family planning, estate planning comes first. That's what you have to do that first. We come in later on. So as what was said, the surrogate court is a constitutional office. Simply put, that just means that the New Jersey Constitution created the office. Each surrogate has a term of 5 years. Each county has a surrogate. And so our surrogate, as you met in Essex County, is Al Tariq Kinney. And we are a court of limited jurisdiction. And so that means that there's only certain things we can do. And so some of those things we can do is probate wills. If there is a will, we can probate will. If that will is contested, we can't probate that will. Our responsibility now changes to be the deputy clerk of the Superior Court Chancery Division probate part. And we have to have that contested will. We have to review what we call an orders for cause and verify complaint and get it to a Superior Court judge. As Mr. Carty talked about, a family fight and conflict. We don't handle that in terms of making a decision on who's right, who's wrong. Most of the time, nobody's right. It's just, people are sometimes dealing with childhood issues. I remember when you stole my bike as a kid, and they're bringing that back up now. Trust me, a lot of times it to you and I can feel silly, but to them it's very important. So in a nutshell, that's what we do. We do handle adoptions. When somebody wants to adopt a child, and adoption can be a part of the estate family plan as well. I won't go into that, but that could be part of the plan where you can talk to a lawyer, talk to a lawyer that handles estate planning or even family law. They can talk to you how adoption works with family planning and estate planning. We also respond, and so adult guardianship, we are the starting point for adult guardianship. So I'm gonna pretty much rehash what Mr. Carty said to kind of flow back into adult guardianship. So he went into details about the important documents that are required for estate planning. A will. A will is the only legal document that speaks for you when you pass away. It determines what you want to do with your things and who's going to handle those things. But he also talked about two other important documents: Advanced Care Directive and Durable Power of Attorney. And when he said living will and healthcare power of attorney, healthcare proxy, many attorneys combine them into the Advanced Care Directive. So when I said, I'm just giving you three, but in essence, he's giving you all of those. So I'm just simplifying it. You need a will. When you go to an attorney, you need a will. You need to walk out that office with a will, Advanced Care Directive, and a durable power of attorney. If you don't walk out with those three things, you in essence haven't gotten, I'm going to say it, proper legal advice. You minimum need those three things. Those are basic bare bones. And as Mr. Carty said, you may or may not need a trust. It depends on your situation. It's fact-based. If you got a business, you might want to put it in there. But I will say this: if you have kids or family members with special needs, you need to talk to somebody who handles special needs trust. Because similar to what Mr. Carty talked about when it came to elder care planning, when somebody has governmental, and actually Ms. McKinney is talking about it too when she talks about Medicare and Medicaid. If a family member that has special needs, whether it's intellectual disabilities or your family member who's elderly, if they have governmental benefits, if you don't properly plan and handle that correctly, you may lose those benefits. So I will impress upon you when it comes to definitely anybody with special needs, you need to talk to an attorney that has that knowledge. Do not do that on your own, because before you know it, that family member has lost their valuable benefits that they need. So trust depends on the circumstance. And as Mr. Carty said, in New Jersey, the probate process is not that difficult. As opposed to places like Florida, even New York is a more formal process where automatically it's a lawsuit. So it's not that difficult. You just have to properly plan. In Essex, our goal is, if you have a will, and let me just say this, hopefully after today, everybody that is in the audience and listening will have a will, advanced directive, durable power of attorney. But if you don't, there's a process to handle those things, but you're letting the government determine who should be in charge of the things, who should be in charge of your health care, and you may not want that person. I think it's, Mr. Cardi, I can't remember for sure. I think he talked about in the discussion, like, family members haven't been there for years and things of that nature. If you had a family member who you haven't seen in 20, 30 years, or a better example is you have, you estranged from your spouse, and that spouse, you're like, I can't stand his or her guts. However, guess what? Legally, that's the next person in line to handle your affairs. Of course, you probably should have divorced them, but some people in their family planning, there's a reason why they didn't divorce them. But I won't go into that. So, but after today, hopefully, you will walk away understanding that you need to plan and have those 3 bare bone documents, and talk to somebody about Medicare and Medicaid, because that's all a part of the plan. Because at the surrogates court, what we try to do is make sure people understand that, because without those documents, and so I'm going to go to adult guardianship as Mr. Cardi talked, without that document, what happens is, if you have, whether it's a child with special needs who just turned 18, because in the state of New Jersey, 18 is the age of majority, and we presume that anybody who's 18 and over can care for themselves and their financial affairs, which we know that's not always the case. And so that's the starting point. But also, as I heard a couple of ladies ask questions about their parents and also their brother. As you know, we have family members who are older who now don't have the capacity. Well, if the appropriate documents aren't to put together, and of course, if you're 18 and have some developmental or intellectual disability, you don't have the capacity to put those documents together anyway. So for those individuals and individuals that could have but did not put the proper documents together, there is something called adult guardianship. And so in essence, what you are doing is asking the court the first 2 things, it's 2 prongs. First, declare the person, the alleged incapacitated person, incompetent. And the way to do that, primarily, there's some exceptions, but primarily is from 2 doctor certifications. Those doctor certifications, in essence, is letting the court know and giving the court what we call clear and convincing evidence that the individuals cannot care for themselves and or their affairs. I won't go into the differences between, guardian of the person, guardian of the estate, and I won't go, because that can be a whole totally different seminar by itself. I just want to give you a gist of, since Mr. Cardi mentioned it, of what it is and why you would come to the circuit court for that. So you come to the circuit court, you do what's called an orders for cause, verify complaint, and there is a packet out there, and if Nikki, you can put the link to it, because a lot of people in the chat section, because a lot of people do it on their own because they want to save money. And I have to admit, I'm biased because I am an attorney, but the packet is excellent. It's an excellent packet that many people do it on their own. So part of the packet, it does everything for you. It lets you know you need the 2 doctor certification, which is the critical piece of having somebody, 1, declared incapacitated. You have to put financial information in there. So a whole host of things you need to put in there so the judge can then determine that if that person is incapacitated. The second prong is, who should be their guardian? Who is responsible for taking care of that person? Because once they're declared incapacitated, they are a ward of the state. And so somebody needs to be in charge to care for them. And so if you are an individual who got dementia later on and you didn't put together a durable power of attorney and advanced care directive, then you're going to have to go to this process. And, and it costs. I mean, the filing fee is not exorbitant. It's $200. But if you, and I will say, I would often say to people, sometimes you do need to get an attorney. No, and it has nothing to do with their intellect. It's because this is an emotional process. And sometimes it's best to get an attorney to help you get through the emotional process, because mom or dad is now, I think Ms. Kinney said, I'm taking care of mom and dad. It can be an emotional process. It's a heavy burden, because what people don't understand is, once you are a fiduciary, whether it's an executor, a guardian, whatever the case may be, you have to, that's a job in itself. And you have to not only take care of yourself, but you're taking care of them. As you asked the question of the lady in office, who's taking care of you? She's taking care of 3 people. And she has 3 jobs. And then on top of herself, 4 and whatever else. So, sometimes it's just easier to pay the $200 application fee and pay the attorney to do it, but you can do it on your own. Nikki has posted the information up there where you can have the package. So our job is to get the packet or the application if the attorney does it, review it, make sure the basic requirements are done. You know, if the doctor certification is not there, we'll say, what's going on? Where's the other certification? In the case of a minor child who is on what we call IEP, individualized educational plan, and if they have an IEP that's, I believe, 16 and about 2 years old, they can use that in substitute for one of the doctor certification. And when I say doctor, the doctor could be a physician, psychiatrist, psychologist, and there's some other exceptions if they have if they're in what we call DDD programs, and I might get all the D's wrong, but the Division of Developmental something. But basically, if they're in a special program, a note can be written from the executive director to substitute for one of the doctor's certification. But that's an excellent packet. So there are times where you're going to have to come to the circuit court for adult guardianship. But if you can avoid it by doing the advanced care directive and doable power of attorney, then I will press upon you to do that, because as a couple of people have said, the surrogate, Mr. Cardi has talked about, is the pandemic. The pandemic has illustrated the importance of those documents. And let me point out, those documents are void when you pass away. So the will is the things that speaks for you at that point. And those things and those documents, doable power of attorney, advanced care, healthcare directive, are void or both. So you can always eliminate it or change up who you want that person to be. So I since that was talked about, I just wanted to address that. The other care piece, the guardianship. Also, Mr. Cardi mentioned a couple of things that I just want to, because sometimes, and I do this, sometimes we throw out legal terms, and sometimes we forget that we got lay people that we're talking to. So he talked about his example about real estate, and it can even be money in the bank. The deed said that it was a right of survivorship. So basically what he's saying is there's a couple of ways where you can title a house and other assets. And there's one thing called tenants in common. So tenants in common simply means, so let's say I use Mr. Cardi. Mr. Cardi own a house together, and it says we own it together in tenants in common. So I pass away first. So what happens, and we own it 50-50. So what happens to my 50%? Well, my 50% goes to my estate. And however my estate's supposed to be divided up, whether that's through my will, or if I didn't have a will, through what the New Jersey intestate statute says it should be divided up. So that goes straight to my estate, and Mr. Cardi still owns his 50%. Now, he may not want to own that 50% with my estate or whoever, but because it was titled that way, that's the way it works. And so the other one is tenancy by the entirety. And so Mr. Cardi and I, and let's say we were married. So and tenants by, so I have to use it that way. I see you smiling because that's what it's for. So tenants by the entirety is when two married people own a property at the same time, and there's a couple of other things that have to happen at the exact same time, but basically they automatically happen. We're married, we buy property at the same time, and again, I pass away first. Well, what happens is because we were married, automatically by operation of law, my share goes to my spouse. I don't have to do anything. I don't have to change the deed. I don't have to do it. I don't have to do a thing. Only time you really if you can change the deed if you want to, because you just want to show under your name, or sometimes you might want to refinance the home, so you might have to do it. But once I passed away, and since we're married, I'm going to call him Jim. Jim doesn't have to do anything. So that's the second one. The third one that he talked about, tenancy with the right of survivorship, joint tenancy with the right of survivorship. Again, him and I, let's just say we're frat brothers, and we decided to buy a house together. But we decided that we want tenants' right of survivorship. So what happens when I pass away? It automatically goes to him. Same as tenants by the entirety, but it has to be titled property. So that's important when you understand the title, as he talked about, because if you're looking, as he talked about, the 3 kids wanting to do it equally, you have to make sure that's done. So I just want to make sure if anybody was unsure about the term, what the term meant. And then he also talked about minors and their money and the surrogates court. So the surrogate court, one of the things we do in Essex County, we have approximately $36 million in trust for minors. And as I said earlier, in New Jersey, you're 18. When you turn 18, you are an adult. But prior to that, minors legally cannot have money in New Jersey. There are some exceptions with there's a $5,000 threshold. But if I pass away and I have minor children, then my estate can't give it directly to my children. That's when trusts come involved. You might want to set up a trust, so it'd be put in trust. But let's say you don't have a will, or you didn't put a trust in your will. Well, what happens is the administrator or executor of my estate has to give that money to the surrogates court in the county that I resided in when I died. And so let me make that clear. Each surrogates court is responsible for wills, administration for individuals that have passed away in that estate. In that county. There's some other exceptions, but that's the general rule. Same thing with the funds. That's the general rule. So that money, so also besides inheriting money, kids get in accidents and they can get money from an accident. And that money also, if the attorney that represented the minor did not make arrangements for a trust or anything like that, then what happens is the judge, after they make a ruling on terms of that kid should get funds, that money will be deposited into the surrogates intermingle. It's called the surrogate intermingled trust fund. And it simply means it's just one big fund where every kid money is put in, but we keep track of it separately. And they do gain interest. Interest rate is very low. It's not a lot of interest, but the money stays in the account until they turn 18. Once they turn 18, then they will get their funds. But the kids, and usually it's the parents who are considered the guardian of their estate, can make withdrawals, but they have to petition the court. They give the surrogates court the petition, but it's actually a superior court judge that determines that. And usually what the judge will allow funds to be taken out prior to 18 is usually for like education, some medical emergency. I will say one of the things that the judges rarely do, and they may do it once. Let's say, so we're in a pandemic, and a lot of people are out of work and they couldn't afford rent. And so the judge may, because they don't want to see the child out on the street, allow for them to pay rent. But that may be a one-time thing, because at the end of the day, the money belongs to the child and the child is not supposed to support the family. So it stays in it till they turn 18. Unfortunately, once they turn 18, it's theirs. So, I don't know about a lot of you guys, but when I was 18, a lot of friends I grew up with, we would have had the best and the shiniest car. We would have probably been eating out every night. Eddie Murphy was big then. We might have been going to his concerts. And so at that point, it's incumbent upon the parents or whoever their guardian is to kind of help them out with it. But unfortunately, there's nothing we can do once we turn the money over. So that's what he was talking about the money coming to the surrogates court. We don't invest it in any stocks, bonds. It goes into a bank account that we do put out a bid and so forth. But as everybody knows, interest rates are so low right now that kids aren't really getting any money. So if you can do a will, you have, and as Mr. Cardi talked about, you want to care for your kid. Part of caring for them is creating a trust in that will to handle the money and a trustee to manage those funds properly. So it can make more than 1-2% interest. And if the kid was in an accident, God forbid, but unfortunately life happens, you want the attorney handling the lawsuit to set up something, whether it's annuities, whatever the case may be. And a trust can be written in such a way where those kids don't have to get the money until they're 25, 35. However you decide you want to do that in the will. And so that's all part of estate planning. Everybody's situation is different. I will say this before I leave. Everybody's situation is different. I used to have tax clients be like, well, such and such got X amount of money. Well, you don't know what they did. You don't know their situation. And so I heard the word communication by Ms. McKinney. Communication is key across the board. You have to communicate with your attorney, just as you would communicate with your doctor, to let your doctor know what's wrong so they can prescribe the right medicine. Communicate, be open, because your lawyer, somebody like Ms. McKinney, cannot provide you the right guidance if you're not open, sometimes you may be embarrassed. Good example of people being embarrassed is, I was married and I had kids outside of my marriage, my union. Well, yeah, but you got to tell the attorney that, because you want to make sure that kids get something. They may eventually, but it might be after a legal suit. And guess what? The money that the lawyers are being charged, it comes out of that estate. So you have to be open, communicate with your family members. So you know your family dynamics, as what was said earlier. So if you know you got a kid that has who can't hold two nickels together, you want to do a special trust for them. But they don't know that if you don't explain it to them. So you have to be communicate. Mr. Cardi talked about, the instructional letter. That letter is important, because that letter you have to communicate, in that you're communicating letter. Okay, I'm telling you right now, I appointed this individual to be the executor, this person to do this, and I don't want you guys to fight over. So that's why I'm letting you know, and I'm letting you know now before I die. When you see this will or whatever the case may be, I'm giving you advance notice. And also, it's important to do that because you may find out the person you want to handle your affairs may not want to do it. And so that's why you have to communicate across the board with your professionals. And it doesn't hurt. So as I said, I started out as a CPA and attorney. Well, if you have a CPA and an attorney, why not let them communicate? Because the attorney understands your legal situation better than your accountant, and vice versa. Let them communicate so you can get the best plan. And if somebody like Ms. McKinney is part of your team, they should be communicating to make sure you have the best plan. And at the end of the day, us at the Surrogate Court, part of our outreach is to make sure people are disseminating this information. And to echo Mr. Cardi, because I am a lawyer, I have to say anything that I say today is just for legal purposes only. I'm not your attorney. I can't give you legal advice. And the Surrogates Court, by the way, because we technically are a court, our staff cannot give you legal advice. We can explain procedures. So if you have any questions regarding how to probate a will, if you don't have a will, how to handle administrations, how to handle if there's something family members are fighting, and what's the procedure to kind of deal with the fighting of the estate. How do you do orders for cause of verify complaint to the Superior Court so a judge can determine what goes on, adoption, adult guardianship, anything of that nature, feel free to reach out to us, because our information has been posted and we can give you all the procedural information, and we can sometimes, do what if scenarios, but we can't give you legal advice. And so, so that's pretty much it, because normally what I do is like ask questions to the attorney, but I'm going to let the people in the audience ask. I do have one question for him. So if I was in a relationship with a woman for 20 years, I had no will. When I pass away, is she entitled to get anything from me?
That's a question a lot of people ask in terms of kind of common law. People will talk about common law marriage. And in New Jersey, I mean, if there was a domestic partnership or civil, there are ways to do things there. But if there was no marriage, unless there's some contract right between the parties, it's going to be difficult for that person to really get access to an inheritance as a spouse would. I mean, a spouse in New Jersey is protected from being disinherited. They have what's called an elective share. They can elect against your will. I mean, there's just so many advantages to being a spouse. And you talked earlier about some people not getting divorced, and I've seen that too, because those advantages of a spouse, some people don't want that person to have, because they really aren't. The marriage has in all effect ended, but it hasn't legally been ended. So I would say in general, that's going to be a scenario when, if you really wanted to care for that person, you really need a will that says, I'm leaving that property to that particular person. I'm assuming you're single and you've been in this relationship, you want that person to inherit from you. Under the intestacy laws, that person would not be the one to inherit. If you had children, they would inherit possibly, or if you had brothers and sisters or parents. So if you want someone that you've been in a relationship to inherit, it's a really, really good idea to have them in the will. That would be my response, I guess, off the top of my head on that one.
Sounds like a great response. And one last thing for me, because I know somebody's here to talk about insurance because it's in that vein. And I think it's kind of talked about, but I just want to be clear. So my will, advanced care directive, my durable power of attorney, my benefits at the job, my benefits outside the job, my own personal insurance policy. How often should I review those things and make changes when life happens?
Oh, was that to me?
That's for you. That's for you.
Oh, I'm sorry. Well, okay, yes. We generally recommend that every 3 years, 3 to 5 years. But with the way things are changing so rapidly, we say every 3 years, people should at least look. Some people will review their planning on an annual basis, okay, which is not a bad idea. But at least every 3 years, or if there's any major change in your life situation. So, if there is a change in marital status, if a new child is born, if there's a major change in your financial situation, those are all reasons to look back at your plan. If there's a change in the health status of an elder, you need to look at your plan, because when you're planning for yourself and your immediate family, but you have to also plan for those elders that you may be called upon to help in their care as well. And so really doing that family planning, but I would say at least every 3 to 5 years, the maximum, but at least every 3 years. And if you could, on a yearly basis, just to review it, that would be the recommendation.
If I could just
Thank
chime
you.
in, as an insurance agent, well, if you have me as your agent, we speak every year, because you'll be amazed. I have one client, until we met in December, his grandmother, who died in 1999, was still a beneficiary on his policy. So as an insurance agent, if Gina McKinney is your agent, we're seeing each other every single year, because life happens, things happen. If you can't afford, we're looking to decrease, because I don't want people canceling, because we still want you covered. So I just wanted to add that in. As your agent, we are seeing each other every year, and we're speaking to each other at least 2 to 3 times a year, because you need that partnership in life. We're so busy living that we forget to look over the important things. So as your agent, that's our responsibility to assist you with that.
And let me ask you, as the agent, if somebody, let's say, forgets to name beneficiary, who gets that money?
Nobody. The insurance company does, because if you don't have anybody down, they're not giving it to anybody. So that's why it's important that we review that, and you need to speak to your beneficiary. And so as an agent, when I deliver, the beneficiary must be there, because that is the time for me to plant a seed of relationship building, because I come in at the point of death, and death makes us crazy and stupid, for lack of better terms. And I'm not going to be made uncomfortable dealing with strangers that don't know me. So it is my goal as an agent to build a relationship with that beneficiary, so that they know that they're not by themselves. I'm here to sojourn with that family through the darkest times. And what we don't understand is that people don't know what it means to be a beneficiary. And I think Mr. Cardi brought that up. Just because they're your child, I have plenty of clients who do not want to name their children as beneficiaries. Is it Cardi? Okay, that's what I thought I said, or Cordy. I'm sorry, boo. I'm gonna get it right. But no, it's very important that beneficiaries understand what being a beneficiary is, because they may not want that responsibility, and we just can't assume. So that's something to even think about. But if you don't have a beneficiary designated, nobody gets that payout, and you need to identify a primary as well as a contingent, because something might happen to that primary, and if there's no contingent there, that benefit does not pay out, and we've made those premiums, and the insurance company just gets to benefit from it.
Well, to add on to it, so yes, there's no individual that gets it, but what happens is the estate of the person who died gets it, and then that makes it even more confusing depending on that situation. So she's correct. No individual gets it. So it stays with the insurance company until the estate comes, and who knows when they're going to come. And so the insurance company, although there are some laws, what they call escheat laws, they're supposed to turn the money over to the estate. but depending on how those laws work, they're benefiting from that money as opposed to your family member, because the whole purpose of this and what we're talking about today is to make sure you care for your loved ones when you're gone. And you know, because if you have a wife and small kids, even simpler than that, insurance policies are used to bury us most of the times, and the money is tied up. And because you didn't name a beneficiary, now they have to go through a longer process possibly to get the money just to bury you. And we didn't even talk about pre-burial arrangements. But but the next person. Oh, as I for the next person. Oh, well, segue.
Talk about that next. Thank you, Mr. McGoogle. It's
Thank
a
you.
pleasure so much. Again, thank you for your service and to our community. And the information was well received, particularly for adult guardianships. I've had the experience of going through that process with a friend. And I can't say enough, if you know your child has a disability or has some other, inability to take care of their business, do that process to get the special trust, the special needs trust. It is expensive, but plan for that. That's all I can say about that. Our next presenter is Anna Costa. Ms. Costa is a field underwriter for Lincoln Heritage Life Insurance Company, specializing in final expenses and family support. Her legal background brought knowledge of contracts and civil rights and passion in caring for her community, guided her to this line of business, the insurance business. She's combined her attitude to ensure that families are taken care of in time of great need. She was born in the US and raised in Brazil, where she was an attorney. Ms. Costa, welcome.
Thank you. Hi, everyone now. Good afternoon. And first of all, I just want to say that I'm extremely grateful to be here because as a final expenses specialist, our job is primarily to educate the families. So this is a great initiative. Thank you again. And I also want to thank all my friends that spoke before me because they made my job a lot easier. Because a lot of the topics that that involve my work were already touched by them before then. As she as Gina, we're colleagues. She knows this. We are daily faced with families out there that have absolutely no idea or a vague idea of what final expenses is. I'm sorry, I lost my line of thought. And the impact that it brings to that family, okay? Yes, people, all of us have some sort of experience, in funerals or know about it. And basically families think that, oh, okay, I'm gonna have a funeral home charge, a cemetery charge, but they don't grasp that it's a lot larger than that. Okay, as it was spoken here earlier today, most often than not, the last few years of someone's life are very expensive due to medical bills. And then you have a family that has been struggling for a while with that, and then boom, death occurs in the family, and immediately that household, that family has to come up with $15,000, $20,000. We hear a lot, oh, but I do have a life insurance. It doesn't matter if you have $100,000, $200,000, $500,000 in a traditional life insurance. I guarantee you those funds will not be available immediately. Okay, that product was not designed to help the families immediately. It usually takes, on average, 8 weeks to sometimes 6 months. So that money is going to have to come from somewhere, right? And we're not talking just about, like I said, unpaid medical bills. We're talking about probate costs, legal fees, monthly costs that the person has, that the family has to come up with. So where's that money coming from, right? That money is coming from college funds or savings for a house, to put down payment for a house. So I usually say that death doesn't kill only the person that dies, it can kill dreams also. So that's why it's so important to have a plan, okay? So now enough talking about, sad things. Let's talk about the good stuff. There is a solution for that, and a simple, fast, easy, and that is going to bring such peace of mind. And God bless America, because honestly, this is the country that has this product. I've never seen this product anywhere in the world. So it's wonderful. How do we do that? Through a program, affordable, okay? We work on what you can afford, not, what, astronomical amounts of money, what the person can afford. 99% of our clients are, on a base income, retired, on a fixed income. I apologize. So how do we do this? We do this through a program that has two sides. Okay, the cash benefit. It is a permanent whole life product that pays out your beneficiaries in 24 hours as the claim is approved. So your family is going to have the money immediately. Very simple, very easy, application process. Honestly, it takes like 30 minutes tops. But in my opinion, the cherry on the sundae of the program is the family support service. Okay. All our clients are members of FCGS, the Funeral Consumer Guardian Society. This entity is a, let's say, they're specialists in taking care of the families. Our families don't have peace of mind. They're not in their right mind, when they lose a loved one. They're not going to make the best decisions with, the money that they have. So FCGS steps in and takes care of all the arrangements. We work with the client ahead of time, understanding what they want, what they wish, what their wishes are. For that, we have something that our friend Carter mentioned. This simple guide. It's called My Final Wishes. And it's the basic idea of what your wishes are and what, location of your documents or, funding for it. This helps your family members navigate through a tough moment. It makes everything easier, organized. Organization is the name of the game, basically. Okay, so FCGS will, step in and take care of everything for the family. So here we have a plan that, will not only make sure that the funds are available immediately, so your state is protected, your life insurance is protected, and your family members obviously are protected, but also will bring, peace of mind to them. So they will grieve. They won't have to worry about where, the money is coming from. Gina, please.
If I can just step in, and she's right. That's one of the things that I do love about Lincoln's Funeral Advantage program, is that it is designed because it's supplemental. So we don't operate like the traditional insurance company. This is simplified, issued. Okay, and so the only thing I want to just bring clarity, our benefits do pay out within 24 hours, but we all know about that 2-year contestability period. So when it comes time for us to make a decision about getting insurance, we cannot delay. So this is a standard, insurance policy, but we all have to get through that 2-year contestability. So the 24-hour payout is once the 2-year contestability period has come, and that's based upon the date of issue. But she's correct. Once Lincoln gets that death certificate, and because if you allow us to help you, you are going to fill out your 2-page final wishes form. That's what you get with every Lincoln policy. And what does that include? Your personal demographics, all of your important information, your name, when you were born, married, what you did for a living, your parents' information. And guess what? That goes to the funeral home. How do I know? Because I've already dealt with my first claim this past May with my cousin who just got covered in December. So because I had that information, I was able to give it to the local funeral home. I was able to get her death certificate within 5 days. Unfortunately, she was only 6 months into her policy. So if she had gone through the 2-year contestability, once I got that death certificate and I uploaded that to Lincoln, her benefits would have been paid out into the bank account of her beneficiary. And why is that important? Because our families need to know that the money is there. What normally happens in our community, the money's not there, and we're robbing Peter to pay Paul. And we're on GoFundMe, and we're trying to figure out how we're going to bury this loved one, and we're not allowed to grieve because we're trying to figure out how we're going to pay it. Lincoln, it alleviates that within the 24-hour period. But what's most important, and I want to say Mr. Carty spoke to this specifically, that I got chills and I almost started shouting. We need directives. People need to know how you want to go, because I've long since discovered that we're burying people and celebrating people as we see fit. We're not honoring them as they see fit. We're grieved and we're spending money saying yes to everything, doves, horse-drawn carriages. I don't know where all this stuff came from, but we're spending so much money for people who are no longer here to see it. And by the time the smoke clears, that policy is exhausted and they're looking for something left over, but your grief has let you spend everything. And so that's what FCGS does. It stops the overspending. It takes control of your final wishes. So if you want to be cremated, your family needs to know that a basic cremation today is $1,100. That's it. Authorizations, get your urn of choice. You have your loved one, and now you can celebrate them as you wish. And did the pandemic not make that our reality? The pandemic wiped out the pomp and circumstance. We spend too much money on funerals, and I do believe we're throwing that money in the ground, and we're leaving people on earth who could benefit from those funds. And so that's what we're here to do. We don't sell, we educate, and we partner, because even though we've experienced death of our grandparents, our parents, this is 2021. The game has changed, and a lot of people don't want to have this conversation about the one thing we're born to do. And so we're here to partner and to sojourn and to educate families on the affordability of this, because as she said, we do believe in budgets. And so you just have to be comfortable with what it is that you can afford. And we cover people from 0 to 85, and even people who suffer from healthcare issues. So if they have heart conditions, circulatory issues, they suffer from diabetes, they have cancer issues, liver, kidney disease, and neurological disease, we cover them. It's at a minimum, but we do cover people with health needs. 1-page application, only 9 health questions. The only people we cannot cover are people who suffer from HIV or AIDS or have a life expectancy of a year or less, or if they're in hospice care, in rehabilitation, or in a hospital. But being independent, we still can cover those people. It's called Gerber. Gerber is the one insurance carrier who has a guaranteed issue product for anybody 50 to 80 that suffers from any condition. So even though we represent Lincoln, we're still independent, and we can still help those people in our community who suffer from those uninsurable conditions of Lincoln. And so we're just here to avail ourselves to the community so that we can educate, but it's not GoFundMe's responsibility to take care of your life. Mr. Carty talked about stewardship over the life that you live and over your material items. I'm a Christian. This is stewardship, and it's my ministry. And so this is why we're here to educate and partner on the importance of final expense, which is also known as burial insurance, but you can use this policy for however your family sees fit.
Yeah. Planning responsibly is definitely our responsibility. And we often hear from clients that a plan such as this is a light at the end of the tunnel for the family members. Because, you know, they're gonna be coached and helped throughout the process. And that's absolutely priceless. Okay. Thank you.
Okay, well, thank you all to Anna, Gina, to all our panelists today. We're going to be closing out shortly. We're over our time a little bit. Briefly, I know there was some expectation to talk about real estate. Was a real estate attorney. That was my primary practice. And I represented quite a few families, usually referred to by estate planning attorneys, because as Mr. Google mentioned, the importance of looking at your deeds to see who, in fact, is titled on those deeds. Are you still married? Did you get the divorce you should have gotten 30 years ago? And I've seen that. And I've seen, you know, I want to leave it to all my children, but each child has issues, or some of the children have issues. You would not want to leave it to a child who is currently a drug addict. I mean, you have to, I mean, it's harsh, but there's other ways to take care of that child. You don't put that child's name on the deed, you know, in your will, for example, or if you don't have a will, that child will get an interest in that property. So it's important to, you know, if you have an asset such as housing, you know, a home, it's so important to figure out what the current title is, what you anticipate the title to be after your passing. Mr. McDougall gave you examples. For example, a husband and wife, you own it as tenants in the entirety. So one spouse dies, the other automatically gets it. Usually when I was doing real estate and multiple people were buying property, I would ask them at that time, how do you propose to hold that property? Like if it was a mother, you know, a parent and a child, I explained to them what the impact would be if you said, oh, we just want to own it 50-50. Well, 50-50, as he said, half goes to that estate, and that could be boo-boo and crazy people, and then the other half is still owned. So again, I encourage in those situations, I would ask that you want to do tenants in the I forgot the phrase already. Tenants, not tenants in the entirety. Oh, tenants would write a survivorship so that the other person would automatically get it. So that's important. Another brief issue I wanted to raise was the hospice. Unfortunately, the person who was to come today was not able to come. And hospice is a service that's available to families. And it's not just for the dying. We have a negative connotation with it. With hospice care does require some criteria where the doctor has to certify that you might have 6 months to live, whatever, but we believe. And, but she had indicated to me and in her materials that the hospice is available to families and to the person who's afflicted. And that should be taken advantage of. Okay, it's particularly when it's covered by your Medicare plan or your health insurance plan. So don't look at it as a negative thing, but look at it as a holistic, maintaining the caregiver's sanity and health as well. Another issue that's been coming up, and I was looking in the AARP, if you're over 50, I think you get AARP. But a big thing that our seniors need to be aware of are the scams and frauds that are taking place against them for their finances, for their housing, for just about anything. And unfortunately, it might be from family members. So if people are coming through your house and, you know, oh, my grandson, my granddaughter's coming through, they might be looking for your paperwork, getting your social security number and other, you know, information that allows them to get credit in your name, and they're buying new cars or whatever. So AARP in their April 2021 edition, you know, talked about the top, well, today's fraud, hot frauds, you know, the Zooming phishing, where everybody's on Zoom now. You know, you just get an arbitrary Zoom invite. If I didn't invite you, you shouldn't be coming on. Or if a known person didn't invite you, you shouldn't just get on. The COVID card, the COVID vaccine cards, where people were showing, oh, I'm vaccinated, but then they showed their card with their personal information on it. fake online shopping sites. A site that looks like Macy's might not be Macy's. So when you Google Macy's and you see ad Macy's, I never click on ad. I click on the Macy's URL document. Celebrity imposter jackpots where a celebrity might say, oh, you know, you're going to win $100,000. And you have to click on. Online romances, those match program, not even for old people, even I'm sure young people getting messed up, where you get on that website, or somebody looking at you and you're providing information, or you're providing money because now you have a relation online, but you haven't met that person. You have not physically seen this person. Now they're in trouble, they need money, and because now you have this relationship, you're gonna send them some money. So Medicare card come-ons, again, with Medicare and the open enrollment, it's gonna be hot these next few months. Okay, so again, if you didn't ask for that information, you didn't call or you didn't get online, preferably if you didn't call, somebody calls me, I didn't call you, so why are you asking me for my social security number? The only time you would do that is if you made the call and you know that you're speaking to that particular agency or the person you called. Cash transfer, app swindles, again, because we now transferring money through Zelle, Cash App, PayPal, whatever, again, you need to know who you're sending your money to. Okay, that shouldn't be an open-ended thing. Social Security scams, spoofing the number. So you think you're calling Social Security and it's really going to somewhere else. And it just goes on and on. Problems with your account. I'm sure you've gotten texts and phone calls that says, oh, there's a problem with your bank account. Really? So again, you need to, be aware of what the target, that seniors are a target. And as Gina said, look at your things on an annual basis. And, look at your deed, look at your bank accounts, be aware of what's going on. Many of our, when they mention about children or caregivers having access to the seniors' bank accounts, which is a good thing. I was on my mother's account, but in hindsight, you should have multiple family members on that account. So I couldn't say, oh, I got to pay my kids' tuition and take money out of her account to pay my children's tuition. But if my sister's on the account, she's going stop. So yes, you should have some assistance in that way. Even with powers of attorney, you usually name one person to be the power of attorney, but maybe it's best to have two people on it. So there's kind of like a check and balance. So no one is taking advantage of the person who we should be protecting, which is our family. So I just want to put that out there. I know we didn't have a lot of time, but again, I thank the Newark Public Library. Yes, we have one more question from our audience.
Is this working okay? Mr. Cardy and Mr. Dougal, just a quick question. The lawyer's responsibility, once you go to a lawyer and you have a will drawn up and maybe a power of attorney, are they finished with you once you pay them? Because, you look at these TV shows and after somebody dies, they have a reading of the will and the lawyer calls the people together and you go in and they tell you what happens. But in real life, I don't think that happens. I mean, who keeps the will? And then who tells you what's in it? So, do you hide it somewhere? And then if you die, nobody finds it? I mean, please answer that question for me. Thank you.
I guess a couple of, let's say, who keeps the will? I'll start with that. Having the original will is very, very important. And I guess Mr. McDougall can talk about the surrogate in terms of if you don't have an original will, it's going to be difficult to probate that because there's a presumption that if the original is destroyed, that you revoked your will. So keeping that original will in a fireproof place, some people will keep it with their attorney. Some people will keep it in a safe deposit box or a fireproof box at home, letting others know where it's at. But that's critically important that the original is safeguarded. You have to go before a judge to probate a copy, essentially, of a will. So, and then in terms of, I guess the other question was who how often should you talk to the attorney afterwards, or what happens about the reading of the will? I can tell you in my practice, what I try to do is I try to provide people legal services as cost effectively as possible. And so it really is a question, a discussion we have with the client in terms of what role they want us to play. And we do touch base with our clients over time. And I do think the idea of especially talking to your insurance people about your beneficiary designations yearly or even more often, that's a great thing, because we come across beneficiary designation situations which are not what people intended, and that causes all types of problems. Or even situations where someone thinks they changed it with the company, they sent it in, they never got confirmation, and lo and behold, it's the wrong person. So doing that on a regular basis, but you really have to talk to the attorney as to whether or not you want to really kind of engage the attorney for additional types of services. But we try to keep in touch with our clients so that they're aware of new things that occur. But we don't, if someone says, look, I just want to do this, this is all I want to pay for and all I can pay for, that scope of service maybe just be, here's doing the plan now. Here, if there's something big that occurs, let us know, come back to us, and there's may not be any charge really to talk to us about that. If we need to do some more things, then you'll do that. But you really do want to, if you can, establish that relationship with the attorney where it's ongoing, where it's back, where you can have that continuity. We look forward to that. But there are many cases where people just say, look, I really want just a very small scope of services. I don't recall what the other question was. I think there were 3 questions.
I think
After the person dies, everybody's like, is there a will? I have a family right now, and that's, is there a will? They're looking through all the dresser drawers, all the places.
Right.
Who was the lawyer? We don't know who the lawyer was.
Yeah.
I mean, so how does the will come up after the person is dead? And who's going to know what's in it? Or if somebody finds it, can they just destroy it?
Yeah, all good. We suggest, there are a couple of things we do in our practice. One is when we have someone sign their will, we actually have another document where they tell us, I'm going to safeguard it myself, or I'm going to have the law office safeguard it. That goes into the file that we give them. It goes into our files. But in terms of if no one in the family knows that you did a will, that's where the letter of last instruction is vitally important, because it says, look, I have a will. This is the attorney that did it. That's a way to know where it's at. So the letter of last instruction and reading of the will, we rarely is that something that's done in my practice. Sometimes we have brought people in to do that, but in most cases, there's not a quote formal reading of the will. As part of the probate process, Mr. McDougall may talk about, notices of probate and providing the will to people. But people do get the actual copy of the will, but everyone's sitting in a room together to read it. It can be done actually with COVID, probably not now, but that's not necessary. And most times in my practice, there's not a formal reading. When someone comes to us about a probate, we will talk with the person that's our client, usually the one that's been named as executor, about what administering a estate involves and how we can help them with the probate process. But I think Mr. McDougall may be able to talk to you more about notices of probate and.
Well, I agree. I agree with what you said. Basically, reading of the will is a bygone thing. It's antiquated, and really, you just get it off of TV. Really, that's really, and most lawyers these days, unless a client asks, doesn't hold the will. It's as Mr. Carty said, the instructions usually is get a fireproof box. It used to be put it in a safe deposit box, but I wouldn't recommend that because I will speak on the surrogate side. we get plenty of people coming in asking us for orders to enter a safety deposit box, even if their name is on the safety deposit box, because banks are not allowing them to enter the safety deposit box once they know one person has died. And so, you know, you might not want to put your will there because your family member might not be able to get it right away, especially if they don't know you have a safety deposit box, because as you talked about, that usually will happen. If there's a lack of communication, as we talked about earlier, there's no letter of instruction. That letter of instruction, the attorney will tell you, you know, this goes to the individuals that you want to be your fiduciary. They need to know what these things are. You're instructing your fiduciaries. When I say fiduciaries, your attorney in fact for the durable power of attorney, even your funeral representative, because a lot of these people that I'm mentioning, lump them together, they don't have to be the same people. They can be different people. So it's important that you have these conversations so they can know where your will is. And fireproof box is the most important, is probably the biggest one, most important one. And so I agree with what he says. And when he talks of notice of probate, so once a will is probated, there is a legal obligation for the person named in the will, the executor, I believe it's 60 days after the individual was named the executor, the will was probated by the surrogates court, for them to make available the will to everybody. You know, a lot of attorneys will just say, listen, just provide it to everybody named in the will, even provide it to the people who were not named in the will, who may contest the will, so they can see it. But to go back to the letter is important, because also if you disinherited somebody, the letter can say, listen, I disinherited my son John for reasons that you can put it in the will, but you also can put it in the letter, or you can make a poignant letter separate for him or her. But yeah, it's tough when the communication wasn't there and the family doesn't know if there was a will. And as Mr. Cardi said, the legal presumption is if you don't find the will, if there was a will, you knew there was a will, you don't find it, the legal presumption is they destroyed the will and it doesn't exist. So you have to do administration. So what you guys are doing, unfortunately, is the only thing you can do, and look for possibly paperwork from a bank that may say there's a safe deposit box. If you do locate a lawyer they use, contact a lawyer. And if you find a copy, as he said, a copy can be probated, however, not by the surrogates court. You have to do what's called an orders for cause, verify complaint, give that to the surrogates court, and basically all you're petitioning a superior court judge to allow that copy to be probated by the surrogates court. The fee for that is $175. If you're doing it on your own, there's no additional fees, obviously, whatever costs it, gas and stuff like that, obviously. But if you use an attorney, you pay an attorney's fee. So you want to avoid your family not knowing what the will is, because at the end of the day, the money you want to give to your family members is going to the pockets of a lawyer. And, look, Mr. Cardi will probably tell you, his hope is not, that's how he makes his money, but that's not what he wants to make his money on. He wants to help people out, his family, and make life easier for you. One, because that's the kind of service he wants to provide, but it's also what he wants to give to the community, his friends and family. He knows this is what friends and family wants, and so he does that, and the surrogate court does that by doing these kind of outreaches as well. So I think I answered the question as well.
Okay, again, thank you very much to all the panelists, Gina, Anna, who were present here today, those that were able to join us, James Cardi, Altari Kenny, and Devar McGoogle from the Surrogate's Office. Again, it was a wealth of information and knowledge. I hope this information blesses your family, that you take action now, not later when it's too late. And if we put in the chat all the contact information for each of the panelists, I believe it has been recorded, so it will be available on the Newark Public Library. And as a member of the Friends of the James Brown African American Room, I ask you to consider becoming a member of the Friends of the James Brown African American Room, and that information can also be found on the Newark Public Library's website. It's a nominal annual membership fee. We strive to provide much needed information to our community. And that's what we do. So again, thank you. Thank you to the library and to the IT people. Exceptional job and good night.
Thank you. This was awesome. I'm gonna do this. No, this was great.